Hi, it's Janet Gemmel with Cape Fear Family Law down here on the southeastern coast of North Carolina. I want to talk to you today about the Gilmartin versus Gilmartin case, Court of Appeals case out of Pasquotank County. Judge Trevette heard it on the trial court level. So this case has three great points about condemnation, pleadings when you're alleging marital misconduct, and porn addiction and social media flirting as marital misconduct. We're going to dive into each of those, but first, let me talk to you about the basic points for this December 2018 case. The basic facts in this case are that the parties were married in 2006, separated in 2016. They had one child. Wife was awarded $1,100 a month in alimony for 48 months, or 4 years, of course. And interestingly, they tried equitable distribution and alimony at the same time in this case, but husband, because he's the one who appealed, only provided the record on appeal for the alimony portion. And so a number of his objections to the trial court order were not even heard because he didn't have the facts in there for the court to make a ruling on it. And the Court of Appeals said, we're not going to make up the record on appeal, and we should not assume one. So let's dive right into the main rules that we can take out of this case. On the first issue that I talked about, pleadings, here's what the Court of Appeals said. If you're pleading marital misconduct, you must plead that the marital misconduct was without provocation. If you don't, it is a fatal defect, and you may not withstand a 12b6 motion on that. Now, the Court of Appeals did note that if you get all the way through the trial level and you did not do a 12b6, well, then you've missed your opportunity. But keep in mind that you must allege that marital misconduct was without provocation. The other thing about pleadings is that you must allege the facts that exist which create indignities with specificity. The court went on to say they wanted to know the acts and the behaviors which led, and you must put those in your pleadings. Not doing so is also a fatal flaw. All right, the second set of rules in this case, condemnation. Now, the Court of Appeals looked at the pattern jury instructions from North Carolina to get to the basics of condemnation, which is a great place for you to start if you're doing some trial prep. Remember that in order to condone any kind of marital misconduct, the spouse who is condoning needs actual knowledge. Now, the court also went on to say that they can have facts that a reasonable person would, make the assumption that marital misconduct happened, but they're requiring actual knowledge, okay? So actual knowledge or facts that a reasonable person would use to know that marital misconduct occurred. A mere suspicion is not enough for condonement. Remember that condemnation can be expressed, where you say to your spouse, I forgive you. I still love you. I still want to make this work. Or it can be implied. And this court went into some great detail about that. So read the case if you want to know a lot more. But here the court said, hey, look, if you stay in the marriage after you know marital misconduct occurred, that's condonement. Or if you have sex willingly, voluntarily, knowing prior to that voluntary sexual act that marital misconduct occurred, that can be evidence of condonement also. And now number 3 for the meat and potatoes. This court found that porn addiction and social media flirting is marital misconduct in the form of indignities. How many of us have this in our cases every day? Right here, me, I do. In this case, throughout the marriage, husband participated in his porn addiction. He even did this on computers and tablets that the children had access to without deleting those former sites. He used social media sites for flirting, dating, and setting up encounters with other women. Wife confronted husband during the marriage about his porn addiction. And you know just as well as I do what he did. And it was very clear in the case. He got angry. Then he accused her of snooping. Then he became defensive. And at last, he asked for forgiveness. No mystery to you. The wife was devastated. She testified that she felt guilty, she was going to counseling, and that her self-esteem was ruined. This court found that the husband's behavior was indignities that rendered wife's life intolerable and her situation bleak, right? The court found that he lied to her and he continued the pattern repeatedly, such that even though she continued to live there, he recriminated. She couldn't condone it because he kept doing it. This case, the Gilmartin case, Court of Appeals, December 2018, out of Pasquotank County. It's a good case for porn addiction and social media flirting, as well as to understand what you need to be putting in your pleadings and what is condonement. This case has it all. That's our state update. I'm Janet Gimmel. Have a great day and keep helping your clients.